Morning, Marshall. Good morning, everyone. Please be seated. For the record, this is the Lafferty versus Jones matters, week 2, day 8. If counsel could please identify themselves for the record.
Good morning, Your Honor. Chris Maddy, on behalf of the plaintiffs, joined by Alan Sterling and Judge Castle.
Good morning, Your Honor.
Good morning, Your Honor. Good morning, Judge Norman Pettis and Kevin Smith on behalf of Jones System.
Good morning. And just I want to mention, as I try to do every morning, in accordance with judicial branch policy, only those entities who have been specifically authorized to film or record or photograph the proceedings are allowed to do so. Anyone else who attempts to do so will have their device or devices confiscated and they will be removed from the courtroom. Okay, so I understand there are some housekeeping issues.
There are, Judge. And I believe this may catch my adversaries, my colleagues, by surprise, or adversaries only professionally. And that is as follows. We intend to call Mr. Jones in our case in chief, and therefore are going to waive our right to cross-examine him because it's a strategic decision based on our assessment of what occurred and its effectiveness yesterday. So therefore, Mr. Jones will be leaving the building in about 5 minutes. My understanding is the plaintiffs are not going to seek to recall him. My understanding is that we are ahead of schedule in this case and that Mr. Jones will appear next week. I believe we've reached an agreement that I may be able to call him out of turn, but only if the plaintiffs have called all of their experts. So he will be here Wednesday or Thursday or Wednesday and Thursday of next week. We think that this will streamline the proceeding, lower the temperature level, and help the jury to focus on what it needs to decide. As to Mr. Watson,
I just remember we have Friday off.
I do remember.
Yes.
I do recall that, Judge.
Okay.
Thank you, Bill, for reminding me. And we've also completed our cross-examination of Mr. Watts. I'm on review of the notes. I have what I need to argue our case. So on that basis, I believe the plaintiffs may have a request for additional time this morning to assess because these are surprising developments, and we defer to the court on what to do there.
Okay. Thank you, Attorney Pettis. Attorney Maddy?
Yes, Your Honor. So we had planned for a longer day today with Mr. Jones and weren't sure whether we were going to get to the redirect of Mr. Watts. It is possible that there may be no redirect. There certainly will be none today. But what we would like to... Excuse me, Your Honor. Yeah, so on the redirect, we are, of Mr. Watts, we are still considering whether in light of this there will be a redirect. It certainly won't be today. But we would like some time to figure out what we're going to do with the rest of the day. We will be presenting evidence today, and if we have until 11:30 to consider that, we'd appreciate it.
That's not a problem. Attorney
One last
Pettis?
thing, just to round out the record, I told Attorney Petty and his team that I would say this. I don't want to be accused of gamesmanship in this regard. I don't believe I have in my pocket a right to cross-examine Mr. Jones within the scope of the direct when I call him in my case in chief. So I want to make clear that I understand that I am forfeiting that right by this strategic decision.
Thank you for clarifying that. Okay.
Your Honor, we have one new filing this morning. We're requesting a charge in connection with yesterday's testimony. I just gave that to Attorney Pettis this morning. My understanding is he'd like some time to look at it. I just wanted to raise that with the court because that would be something that hopefully we could address later today.
Okay. Is it something you want to share with the court now or after Attorney Pettis? Is it filed in the file?
Yes,
Oh.
yes, Your Honor.
Okay. I checked the file early this morning, but I haven't checked since.
Right at about 9 o'clock.
Okay. All right. Anything else before we recess until 11:30? No. Attorney Maddy?
Not from us, Your Honor.
All right. So I think the plan would be, and we'll tell our staff, they'll all take their morning breaks, and we should be able to then go right from 11:30 to 1, and then we plan on having a pretty full afternoon.
That's our hope, Your Honor.
Great.
We're gonna
Okay,
do
so
what
we
can.
are in recess then until 11:30.
All rise, please.
I printed out the filing from today. Should we address that?
We have a preliminary matter before we get to that, Your Honor.
Okay.
So let's do that first.
Sure.
Your Honor, we were prepared to complete Mr. Jones's testimony today. We were planning on it. We expected that would take a decent part of the day. We were informed this morning that Mr. Jones is electing not to retake the stand, but to return to Texas. As we were scrambling to figure out what evidence we could present in his absence, which, as you can imagine, given the nature of our client's testimony, is very difficult to do, Mr. Jones was giving a press conference outside the courthouse where he continued his efforts to undermine this trial, attack the court in ad hominem fashion, and make personal attacks against counsel here and our families. He also spoke at length about issues this court has ruled are inadmissible and not for the jury's consideration, including raising his bankruptcy, a host of political issues, and in addition,
there's no gag order here.
there isn't,
And
but
the jury has been instructed ad nauseum about avoiding media coverage.
I understand, Your Honor. He also, though, called on the jury to do research themselves into issues relating to this case. So as we were, and the reason I'm raising this, Your Honor, is because as we were considering our evidentiary presentation, this came to our attention, and we started to consider what relief might be appropriate for us to seek. In light of all this, and in light of our the unfairness, we think, at this point, of forcing us to present evidence and highly important testimony and charged testimony in a way that we weren't planning, we're going to ask for an adjournment today and a return next week.
Can I just a couple of things. Is the adjournment over objection or by agreement?
By agreement.
And then may I ask, the press conference was in the front of the courthouse?
Correct.
Was it when the jury had already reported in so that there was no issue about the jury overhearing a press conference?
It was immediately after we took our most recent recess.
All right. Ron, Mr. Farr, do you know if the jurors stayed in the building or not?
4 jurors went out.
Okay. All right. So, Attorney Pattis, let me ask you first. Do you have any independent knowledge? Do you disagree, or do you have no knowledge about the press conference? Because my concern, obviously, is that your jurors are, going in and out of the courthouse. I mean, I suppose I could canvass them on it, but do you have any concerns, or do you disagree with the press conference and the calling on the jury to do research? I just need to know what to do here.
Let me tell you what I know. I know that Mr. Jones is going to address the press. I observed from the 3rd floor of this building a gaggle of people. Couldn't see who was there. I asked somebody, is Jones speaking? He is. I overheard audio recording of it from one or more reporters who were listening to it from within the building, but paid no particular attention to it. It's my understanding of the law of the case that I and counsel have independent rules, and even in the absence, independent obligations, even in the absence of a gag order, not to make prejudicial, extrajudicial commentary, and I think all of us have taken pains to do so. I'm unaware of any gag order as to Mr. Jones.
There is none. That's my whole point. There's no gag order, but my concern is just that, the jurors go in and out of the building, and
if in fact, I don't know, I think that we have a presumption that a properly instructed jury follows the law. The court tells them every day to report. The court confirms each day when they arrive that they have not sent a note, thus alerting them to the possibility that they can. They were alerted that there'd be press. They can see for themselves that there is press. I don't think there's any indication that they have seen something. I think given what, I credit what Attorney Maddie says. If he's listened to it, he's heard it. And I apologize personally. I feel mortified that families were involved. I just have no independent knowledge of that. I mean, I'm moved by it, but I think with respect to the interest I'm defending in this courtroom, I think there's no showing to disturb the jury at this point. I think a properly instructed jury is presumed to follow the law, and there is no gag order. And absent some indication of the jury of the need for a canvass, I think this would just be drawing attention to an issue that may be a non-issue.
Well, I think I will address with them, reiterate this morning, just confirm that they are to continue to obey the orders, not to do any independent research. And I think it might not be a bad idea, since some of them did leave during this time, to at least give them an opportunity to, I don't know, let Mr. Farrow know if they did overhear anything.
You know, I mean,
On that note, I will say the jurors who left were escorted by me to the fourth floor garage and all took their cars out State Street, which forces them to go north. I don't know where they went after that.
So you think that they did not go near the front?
They didn't walk near the front.
All right, well, that's reassuring. Okay.
As to the, as to the adjournment, I'd love the day off.
I couldn't hear you say
I
that.
said I'd love the day off. But I think we have an agreement that Mr. Jones will be available and can potentially be taken out of turn, and that he will be available Wednesday and Thursday, but will not. But I have the right to call him after the presentation of all of the experts, and so I want to make sure that the adjournment doesn't prejudice that, because I know we're off next Friday.
you don't anticipate that this will create any significant change in the expected schedule. So, Your Honor, I did want to say that we, as I mentioned earlier, we are considering whether we should be seeking the relief you've been discussing with Attorney Pattis, and we're going to try and figure that out this afternoon. And so I think with that, if the court wants to have the jury back down, I do think the jury should be not only given the normal admonishment about media and press coverage, but also informed about why it is that we're not having evidence today, which is that Mr. Jones has elected not to continue his testimony at this time.
Well, I think we probably led them to believe that he was resuming the stand. And I was wondering if you had some agreed upon language so that they're not confused or left to wonder. I'm sure you can come up with a sentence.
Something quickly.
Can we do that? Because we did bring
Yes.
them down, and to address Mr. Watts too, because I think we need to at least let them know and put it on the record. Why don't you talk to each other? And
Your Honor, in terms of the Watts issue, I just wanted to let the court know that we had planned on him resuming his testimony today, and that we had planned that he would resume and be the balance of the day, so to speak, after Mr. Jones, or maybe at that point I think we were thinking Mr. Jones might have been done yesterday, but he was our planned testimony. And through no fault of Mr. Pattis, as I understand this decision was made by his client this morning, but last night in discussions with Mr. Pattis, we sort of agreed that if he was going to end his cross of Mr. Watts, we did not feel that it was necessary to bring him back and do a redirect. That is a decision we would not have made had we known that Mr. Jones was going to, at the last minute, pull out of today's testimony for whatever reason he did so, and give a press conference, I guess. But in any event, I just wanted to explain to the court, because I think that if I were in the court's position, I would say, well, what about, or don't you have prepared testimony? And the answer is, we did with...
all right, I'm not concerned. I think that we have an agreement on it, and it's fine. I just want to make sure the jury is not confused or left to wonder or think, that the cross is going to pick up on another day. Or
I want to keep the lines of communication open with my colleagues, and I accept Mr. Koskow's representation. Last night, the agreement was no one was going to recall Watts. Mr. Jones followed my advice this morning. That was my decision. The agreement as to Watts was made beforehand. If they want to revisit it, it's fine. We can talk about that. But as to what to tell the jury, may we have a moment?
absolutely.
My claim would be that we can simply tell the jury that Mr. Jones is, counsel for Mr. Jones is elected not to call him at this point.
unforeseen circumstances, the question of Mr. Watts, you expected him. Oh, I mean, you guys have talked about maybe calling.
Ron.
Hang out there, and we told him to be back, right? Okay, so then I would say the follow-up, then that, the court, that Lynn was pointing that Mr. Jones's counsel was waiving his right to cross-examine Mr. Jones, and, as a result of that, the parties are unprepared to present additional evidence. Oh, I'm not trying to back off. What are you proposing? Mr. Jones testified on direct examination yesterday. This morning, the examination yesterday, with the expectation that he will be cross-examined by his counsel this morning. Mr. Jones has decided not to continue with cross-examination. No, I don't do that. I mean, I don't like you not to cross-examine.
Anything wrong?
I haven't made that up. But it's his decision. No, it's not. I made it. It didn't make him, but I made it. This isn't a criminal case where you have to can't. It's not. It's civil. It's something different. But it's in which, you know, there's nothing, there's no. I just want to get out of the room and go back to the defense.
What is that noise from?
We have,
Just one moment.
I'm sorry.
That's all right. Okay.
Yes, and I think we might want to run that. We're still well ahead of schedule.
I was going to start out with that, with the good news. Lead off with the good news is what I was going to do, that we're ahead of schedule.
Your Honor, we've agreed to the following language. Mr. Jones testified on direct examination yesterday with the expectation.
Is this written out so is it legible?
Good luck with that.
I can make it legible.
No, that's all right. I can just go ahead.
Mr. Jones has chosen not to. Let me begin again. Mr. Jones testified on direct examination yesterday with the expectation that his cross-examination would commence today. This morning,
Or just a little slower.
Yep.
Sorry. So far, I'm in agreement.
Shake
Okay.
Jean.
Yep.
This morning, the defense decided not to cross-examine him. As a result of this decision.
Just hold on.
Yep.
I'm going to add in which is their right, okay?
Yes.
So this morning, the defense decided not to cross-examine him, which is their right, okay?
There's an additional issue.
the next sentence would be, the defense expects to call Mr. Jones in its case next week. As a result of this decision,
Just
there,
let me write it down. All right, as a result, go ahead.
as a result of this decision, there will be no testimony today. And if you'd like to add,
Just no evidence today,
No
is what I'm
evidence.
saying, okay. All right, so, I just want to circle back to, do you have any suggestions, Attorney Pattis, on the issue of, your client calling on the jury to do research? Do you know anything about that, or do you not even know anything about that? I know.
I don't. I didn't watch the press conference, didn't attend it. I knew it was taking place. I knew that Mr. Jones intended to speak to the press. I didn't script or advise or not advise. You can imagine that a cautious lawyer might say that his client might not want to, especially after having had some of the disciplinary rulings here. From the dozens and dozens and dozens of criminal cases I've been involved in, every time I've complained about something with the jury, I'm reminded by a court that the properly instructed jury is presumed to follow the law, and absent some showing that that presumption has been rebutted, I don't think the court should act. I understand Attorney Maddie's concern. Frankly, the thing that is most troubling to me about the representations made in court is that counsel and their families were mentioned.
Well, I was going to get to that.
And may we approach on
Yeah,
that?
no, I'm going to do everything on the record, but on this issue. But the only thing I would say about your prior experience, and I understand that, but this is not the typical case. I think we can all agree, and that this particular defendant has a platform that probably no other clients have had. So it's just. Let me just finish.
I cut you off. I'm sorry.
Yeah. So it's just. I've not been in a situation where a defendant who has a platform like this defendant has had a press conference on the courthouse stairs calling upon the jury to violate. If it's true, no, I don't know. I'm just.
I'll accept it as truth because I respect Attorney Maddie as a fellow all through the court. The only other case, Judge, that actually has attracted the amount of personal scorn, death threats, and animosity toward me in Connecticut was the Tony Moreno case where the 7-month-old child was thrown off of a bridge. And the level of, and it was also televised, it was widely covered, and there was enormous hostility. And I had concerns about coverage, especially given some of the out of the jury's presence covered hearings that took place and were televised. And I would ask the court repeatedly for canvasses of the jury to make sure they hadn't seen anything. And that was the answer. So I would say that while Mr. Jones's platform is sui generis with respect to its national reach, I think the Moreno case was equivalent in public interest in Connecticut and the hostility that it generated.
Right. I'm not. And the hostility is a different issue. It's just unusual to have someone with a platform that is putting out the message, if it's true and I haven't seen it, encouraging the jurors to violate their oath by doing independent research. And I'm not suggesting, I think we have a very conscientious jury. They are here early for every time they need to return to court. But my concern is that someone else, they're not watching the news, but someone, their family or their friends hears that they can do independent research and approaches a juror. So I'm wondering if you have any suggestions or if you think it's, in your own opinion, no need to do anything.
I'm an advocate. I don't want to alert them to it. On the other hand, Judge, I recognize and respect the court's inherent authority to see that justice is done, and I believe this is a discretionary call, and I'll defer to the court. I don't believe it's necessary, but I'll defer to the court.
Attorney Riley? I don't know if you have anything to add upon this issue, and then I just wanted to touch upon, because I was concerned, and I don't have any details at all, but I just want to make sure we don't have any issues with respect to the families or the lawyers. We've been down this road before with the lawyers, and it was an unpleasant road to be on.
We don't want to make an issue with that, Your Honor. I just wanted to.
Well, you may not want to make an issue of it, but this is, at the end of the day, my courtroom, and I have to accept responsibility. So if there are issues, I want to know about them.
What I would suggest, Your Honor, is that you give the jury the normal instruction that you give them every day. We would like to take the lunch break and come back after lunch to present any arguments we may have concerning the appropriate remedy or relief here.
We're gonna need to do it before the lunch break, so I'm happy to take another break to give you all some time to think about it, and also we need to address the issue on the charge unless you've already addressed that.
I don't know about that.
We don't have agreement on that, Your Honor. We would need to present that.
Okay. All right, so do you want, I suppose I can bring the panel down now and let them go. Okay. So Ron, whenever you're ready, please. Good morning. It's still morning. Good morning. Good morning. Hello, everyone. You can have a seat, but don't get too comfortable, and I'll tell you why in a minute. Everyone can be seated. Counsel stipulate that our entire panel has returned.
Shoot.
All right. You'll see we're not handing out the notebook, so I have some information to give you. So let me start off with the good news. It's always good to lead with the good news. We're ahead of schedule on the trial. When we, it's always hard. It's more of an art than a science, but it's always hard to pinpoint exactly how long the trial is going to go. And I know we told most of you that it could go into late October. We are actually sort of ahead of schedule. So I can tell you that the case will end at the latest mid-October. So those of you who need to make plans for vacations or work or anything, you can plan about that. Now, you will recall yesterday that Mr. Jones testified on direct examination, and our expectation was that the cross-examination would commence today. This morning, the defense decided not to cross-examine him, which is their right, and you should not place any blame on anyone for that. The defense does expect to call Mr. Jones in its case at the end of next week. So as a result, there is no evidence that's lined up for today. We have business to do, and we have no evidence to present to you, so we are going to let you go early. I'm sorry if we had known ahead of time. Of course, we would have let you know yesterday so that you could have gone to work or whatever, but I hope that you will continue to be patient with us because all of us are doing the best that we can to make this as efficient and pleasant as possible for all of you. Now, I have a couple important things to say, and I know I'm repetitive with this, but it's because it's so vitally and crucially important. You're not to do any independent research with respect to anything you've heard. If anyone in your lives, family, friend, whatever, approaches you and says, you know, you actually can do independent research, I am here to tell you that you may not. And as I said, you can't Google a single name, you can't look anything up. So if you are approached by anyone who suggests, oh, that's not the case, I'm here to tell you that it is. So you do need to follow my instructions that regard, and I am actually very confident that you will. You're a very conscientious jury, you're here early, so I don't have any worries about that. It is also vitally important that you continue to avoid any media coverage, which might not be easy, but if you come upon it, you immediately have to turn the page or turn the channel or swipe the screen or whatever it is that you need to do. And also, just as importantly, especially on certain days, you're going to see more press than you would normally see, and you might even see some press conferences. Steer clear, because we do not want you to overhear anything at all that would jeopardize your ability to serve, okay? So there were no notes today, which is wonderful. But if there needs to be a note to Mr. Ferraro where you were unable to avoid either the media coverage or anything else, that's okay, and we will be prepared to hear it because we do need to know if there are any issues at all, okay? So with that, I am going to let you go for the long weekend. We will pick up with you again next Tuesday. We're going to start right at 10 o'clock, and we will have a full day. Again, I apologize for bringing you in today, but hopefully you can enjoy an early start to the weekend, and hopefully the weather is going to be nice this weekend. Is it cool? Yeah, it was chilly today. All right, folks, so we're going to stay on the record. We're going to let you go, and we will see you Tuesday, okay? Stay safe. So what do you need, like 15 minutes?
Your Honor,
You can be
my
seated.
preference, Your Honor, if we could, would be to take up the issues that concern the press conference, which we need to talk about. So we need to go on break to do that. And the charge we could take up this afternoon if we have time, but we could also take it up
Yeah, I'm going
Tuesday
to, now
morning.
that we're
So-
not going to be in session this afternoon,
Right.
we're going to deal with all our issues before lunch. I'm sure that'll give everybody opportunity to get back to their offices and do what they need to do.
Judge, I run a report, I'm not going back to my office.
Beg your pardon?
I'm not going back.
Okay, well, wherever you're going. All right, so we have to discuss the issue about the press conference, is that what you want? And then the
Your
issue.
Honor, what we'd like to do is take some time. We need to talk internally about how we're going to respond to that. So we need to.
Is
go
it
on.
something that the court needs to be involved in?
This discussion? No.
No, I mean, after your discussion, what is the end result here that we're looking for?
Your Honor,
Or you want to talk about it
we don't
first?
know yet. We
Okay.
don't know yet.
Is it
Since
something-
we may be seeking relief, we would.
Is it something that that you have that you can share with Attorney Pattis?
Not
No.
yet, Your Honor. We're responding to things that are happening, in real time. So we need a bit more time to figure that out.
Okay. So it's 12 o'clock. Do you want to come back at 12:30? Does that sound like a plan?
Yes.
Okay, we'll see you at 12:30 then.
Thank you, Your Honor.
All right.
Good afternoon, Your Honor.
Good afternoon. Okay.
Your Honor, during the break, we submitted to the court the law and crime URL for Mr. Jones' press conference that took place outside the courthouse. And what we, first of all, let me inquire